about to start now this panel about the crime of aggression, its background, how it forms up as an international law crime, and what advance has been made recently in setting up an aggression court. We'll discuss some of the issues that have bedeviled the problem of bringing aggression as a crime to court. I suppose the first thing to ask is, where is the crime of aggression? Where do we find it in the history and in the practice of international criminal law? Perhaps the best reference is the judgment at Nuremberg itself, when it was called the supreme war crime. Why was it called that? Well, of course, it was before the Genocide Convention, and we find a fairly arid argument between scholars as to whether what is the worst of war crimes, aggression or genocide. Genocide, of course, came into the law in 1949 with the Genocide Conventions. But let's put that aside and go back to Grotius, go back to the great originators of international criminal law. What did they say about the crime of aggression? I think the best definition of it was that given by those early jurists. If I can find it, I'll just read a section from Vattel, who said, "A sovereign who takes up arms without a lawful cause is chargeable with all the evils, all the horrors of war, all the effectuation of blood, the desolation of families, the rapes, the acts of violence, the ravages, the conflagrations. They are his works and his crimes. He is guilty of a crime against the enemy. He is guilty of a crime against his people. And finally, he is guilty of a crime against mankind." So that was the view of the early jurists, that in effect one who starts a war has strict liability for the consequences, for the deaths and dismemberments that are caused in that war. And of course, that definition fits Vladimir Putin like a glove. He's now, 500,000 of his own people have been killed, probably half as many Ukrainians and many citizens and civilians in Ukraine, as a result of a war which no one but he started as a person able to give those orders. However, the Nazi leaders were put on trial at Nuremberg for crimes against the peace, which effectively aggression. Their trials began with the prosecution showing movie-tone news of the Nazi tanks as they moved across European borders one after the other. That was the crime, invading another country without just cause. And that is the crime which the United Nations and the International Criminal Court finally decided upon. It was not until 2010 at the Kampala conference that it produced a definition of the crime of aggression, crime which constituted invading a fellow member of the United Nations without just cause, the only just cause provided in the covenant being self-defense, and no one suggests that self-defense was relevant to Putin's decision to invade Ukraine, other than, and of course, Russia sent a note to the United Nations saying that it would rely on self-defense, in the same way that George Bush relied on self-defense for invading Iraq back in 2003. The idea of anticipatory self-defense, a perversion, I think. Most international lawyers think of international law under which the mere possibility that the target state may join NATO and attack because of weapons of mass destruction or whatever in the future could provide a defense to invading another country. However, that is how international law stands. There is a crime of aggression. It is defined now in the ICC Charter ever since 2010, and it does involve the invasion of another country with sufficient gravity, force, and to make it a breach of the UN Charter. And that certainly was the case with Ukraine. But what has happened? Well, Russia was allowed to get away with it. There was no court that could try it because the ICC crime is limited to members of the ICC. And Russia is not a member of the ICC, nor is China. If it wants to invade Taiwan later this year, it will have no court or the Taiwanese will have no court to appeal to. There is this complete lack of enforcement. So what was the world to do, given this monstrous breach of the Charter, given the deaths of so many hundreds of thousands of people, many of them civilians? For a year or so, nothing happened. We just stood by and watched. But eventually, of course, Ukraine, the target, was keen to have some form of prosecution of the masters of its war. And so the European Union stepped up with some 40 states. We always got to exclude Viktor Orban's state, but for at least 39 countries supported the creation of a court with Ukraine. And so an international court has been cobbled together. But there were a number of problems on which nations disagreed and which will need to be solved if this court, for one, is to have effect. One of them is the question of trials in absentia. At the ICC, you can't have trials in absentia, thanks to American and British jurists who were hung up on the need to have the defendant there in person before the trial could be effective. That is not actually the standard set by international law. Many European countries do, including Ukraine, importantly, do allow trials in absentia if there is an opportunity for the convict to come back and have the trial started again in their presence. There was a trial in absentia at Nuremberg with Hitler's secretary, Martin Bormann, was prosecuted in absentia. He disappeared and no one knew where he was, and he was defended very effectively and prosecuted and convicted, and no one has raised any question about that conviction or that precedent as a trial in absentia. But there it is. That is the first, because if the court doesn't allow trials in absentia, it may well find itself without any defendants. The other question that arises is the international law obsession with state power and state immunity. Can a head of state be prosecuted? Not in any national court. That quite clearly is the law. The people who've put this court together seem to have reached a compromise they will allow state immunity, so heads of state cannot be prosecuted until they retire or are overthrown or cease to be heads of state. So if that is upheld as the final view of the court, then I fear that Vladimir Putin may be head of state for quite some time. The other question that bedevils national courts who try to prosecute international figures is amnesty. Should an amnesty be allowed? Many UN courts, including my own in Sierra Leone some years ago, decided that amnesty was not appropriate for defendants of crimes against humanity's charges. So that is another issue. Putin would come festooned with amnesties given by his own parliament. And of course, one notes now in the age of Trump deals that the deal with Russia and Ukraine for ending the war that was brokered by Trump included a massive amnesty for war crimes to leaders on all sides. It's questionable whether the Trump administration actually acknowledges the existence of war crimes. They certainly don't seem to when they kill sailors clinging to the wreckage of the Venezuelan boats that they send to the bottom of the ocean. But that's another question. At the moment, we're looking at the crime of aggression and to what extent it applies today to a leader who invades a United Nations member and causes hundreds of thousands of deaths and dismemberments. So that being the background, I'm going to go round the table asking whether you are in fact in favor of the prosecution of Vladimir Putin and the way it has been developing. I apologize for getting your names mispronounced. I grew up in Australia where we don't know how to articulate European names or those from America, South America. But nonetheless, perhaps I can begin with you and ask you, Ruti Title, what you make of the proposals for a court of aggression.
I can see that it would be a step in the right direction in terms of anti-impunity as generally understood. My concern is the connection between the jurisdiction and the norm. So, and the priority here. Should the priority here, in terms of the narrative of what Putin has done and other leaders that are being considered for this aggression tribunal, should the priority, given decades after Nuremberg, be the question of state security, of the invasion of state borders, as opposed to human security? And so this is something, that preoccupies me. If you think about Nuremberg, it was an occupation court, a military tribunal, a victor's justice. Since that time, there hasn't been a similar prosecution for aggression. And in fact, if we think about the legacy of Nuremberg, even if at the time, as you rightly said, that was the most important charge, certainly with the vantage point of history, we think of the legacy of Nuremberg in terms of crimes against humanity. And all of the subsequent ad hoc tribunals emphasized systemic mass atrocities. The Balkans, where there could have been a charge for aggression, it was ethnic cleansing of the land, persecution of persons and peoples. So it would seem that as a global community, the question of judgment here and the normativity is a real concern. We've moved beyond that preoccupation of only the concern for territory and state borders. And the ultimate message, I think, 20 years later when the ICC 20 years ago, when the ICC was established, I think that there, again, the fact of the postponement of the definition of aggression and its limiting went to this question. It goes to the anxieties that the crime of aggression raises, the possibility of politicization, et cetera, et cetera. So that's my major concern, and I think that now we have an indictment against Putin for crimes against humanity. The indictment is out there for the kidnapping of children, which is a horrific crime. And there are other possibilities, universality jurisdiction, the principle of complementarity that is associated with the criminal court. And so, there are possibilities out there. I'm also concerned, as you've raised, with the due process, the fact that without defendants, it's a show trial, and the possibility of trials in absentia certainly raises that preoccupation. Thank you so much.
The danger of it turning into a show trial, Albie, would you support that?
It would be a show trial without the accused.
Fair enough, yes.
So it would be a kind of empty trial, a rhetorical trial. I was put in a spot when I was asked to say something to urge the creation of and justify the creation of this permanent court. And my initial reaction was, we've got courts, we've got international law. It's being flouted right now. Our job should be not to try and jump over the problems that exist by creating an ad hoc response to something that's particularly galling, but to defend what exists. Now the rule of law, international law, is being so undermined in so many ways. I find myself in a very uncomfortable position of being a conservative. I've never been a conservative my whole life. I've always been on the side of change and advancing and trying out new things. But these new things that we tried out and we achieved, they were very hard won. And they're being destabilized. And my concern is this would add to destabilization. That's number one. The other concern is the principle of you don't create a law to deal with one person. It's a kind of foundational principle. The generality of law is undermined. And, well, you've said it's to deal with Putin. I'm not going to mention any other leaders in any other countries today, but he's got strong competition when it comes to aggression. So why single out the one and not the other? Now, this caused me a lot of discomfort, but discomfort can be great. And in these last 90 seconds, I've come up with an LB sleight of hand, and I haven't even got a hand to slay, or whatever the word is. A trial in absentia makes a moral point of significance. The punishment might be, if there's somebody up there listening to the misdeeds on earth, he won't make it into heaven, but it won't destabilize the person at all, and it would almost underline the impunity and reinforce the impunity. I'm thinking now, what are the problems in the approach that you're suggesting? People feel anger, disappointment. There's such flagrant disrespect for norms. You send troops in, you're bombing, you're destroying electricity, even leaving out the children and the particularly egregious aspects and so on. And somehow, other than sending arms to support the invaded country and a lot of rhetoric, it seems like the world is helpless. But it's not all countries feel that way. So I'm quickly now trying to create a response that might have some meaning. And that would be if the countries of the willing identify themselves and they set up a court, and the court will, with the support of these countries, if the court makes a determination that X is what used to be called hostis humanis, an enemy of humankind, you make that pronouncement and you say that person is not welcome to come to our country. We shall not trade with that person. We shall not allow that person to have bank accounts. It's a kind of sanction that's being used by executives in other countries. If this sanction now becomes more generalized, then it hurts not a huge amount, but it hurts a certain amount. It can be done in absentia if the person can't be captured and doesn't voluntarily come, and it has some practical implications. So the states now are saying, we don't only condemn what the president has done, but he is forbidden to be treated in our country with the respect that we would treat other other prisoners. So that's offering now an LB invention, and it's safeguarding my own concern that I've just become a total conservative. I would see something where the form of both the jurisdiction, the practicalities, and the sanctions are feasible. And if they're feasible, even if it's only in a small way, something small that's feasible, that functions, can be very telling. Something that's grand, that's unfeasible, will just look like an empty pretension. That's the LB proposal.
So you would support the use of what we call Magnitsky laws against the violators? So this would be an international tribunal imposing Magnitsky sanctions on aggressors that they would...
Countries that voluntarily accept
yes.
norms and standards.
Yes, which would exclude Russia and Belarus and North Korea and China and so forth. But it would have such force as presumably there'd be a declaration, there'd be a judgment, there'd be reasoning behind it. And it would be an international court, except one without criminal jurisdiction. That's interesting. Now, I'm going to bring in, if I can, we have our guest from Ukraine who has suffered the consequence of Russian aggression. And you are aware, no doubt, of the attempts that have been made to set up a criminal court, of Albi's suggestion for an international civil tribunal. How does it strike you?
Thank you very much for providing me a floor. The warmest greetings from the frozen Kiev. My name is Alexandra Matvichuk. I am a human rights lawyer. I am documenting war crimes in this war which Russia has launched against Ukraine. When large-scale war started, we united our efforts with dozens of organizations from different regions. We built a national network of local documentators and covered the whole country, including the occupied territories. And working together, we jointly documented more than 97,000 episodes of war crimes. It's a big amount, but still just a tip of iceberg. We face with unprecedented amount of Russian war crimes, and 4 years ago, when Russians tried to siege my city, I refused to evacuate. I continued to do my work on the ground, and I start to ask myself, for whom do we document all these crimes for? Who will provide a chance for justice for enormous amount of people affected by this war. Because being a lawyer, I understood that we face with accountability gap which have different dimensions. And today we discuss one of these dimensions. There is no international court which can prosecute Putin and top political leadership and high military command of the Russian state for the crime of aggression. But all atrocities which we documenting, it's result of their leadership decision to break the peace and to start this bloody war. And there is something more than that. If we want to prevent wars in the future, we have to punish the states and their leaders who start such wars in present. It sounds like a common sense, but in the whole history of humankind, we have only one such precedent for punishment for the crime of aggression. It was Nuremberg and Tokyo's tribunals. And past century, it's established a huge step towards law and justice, but it's also established like a norm that justice is privileged to winners. Because on Nuremberg trial, Nazi war criminals were tried only after Nazi regime had collapsed. But we live in a new century, and we have our own historical goals. And justice is not privilege. Justice is a basic human right. And that is why we cannot wait. We must establish a special tribunal on aggression to hold Putin and his surrounding accountable. Last June, Council of Europe made the historical agreement and announced the first step in creation of special tribunal on aggression. And frankly speaking, we and other Ukrainian human rights lawyers were expecting that countries, at least European countries, would join to the special tribunal just in the near future. Unfortunately, only several countries joined. And I finished my remarks with two questions. What prevents other countries to join to special tribunal on aggression, especially when we speak about countries from the core group? And second, what altogether we can do to convince them to do this?
Well, the answer
Thank you very
may
much.
be the Trump accession, because Biden donated $1 million to this project. As soon as Trump became empowered, he withdrew that, even that rather mediocre amount of money. And there is a kind of fear, certainly in European countries, of doing nothing to alienate an organization, an administration that doesn't think much of war crimes, doesn't think about it at all when it provides peace agreements for Gaza and for Ukraine. Do you expect European countries to go it alone without America? Or do you identify Trump's America as a problem in achieving justice?
I'm sorry if it was the question. Unfortunately, I didn't hear it. The connection is not very good. I couldn't follow the conversation.
Well, thank you.
Can you repeat? It was a question for me.
Yes, it was. If you see Trump's administration as a problem in the way of European support for Ukraine.
Okay, thank you very much. I understand the main sense of question. I hope so. There is no illusion about any points of accountability in a future peace deal, because it's obvious that justice is not a priority for President Trump administration. It's obvious that Russia will not sign any peace agreement with just a mention of accountability of Russian war crimes. And that is why our strategy is the following. We must make justice as an independent, parallel international track to all peace negotiation. Let me explain. Probably you remembered that in first 28 points plan, it was the total amnesty for all Russian war crimes, which resulted in a huge discussion in Ukraine and other countries, how it can be so. But even if it happened, International Criminal Court will not stop its investigation. International Criminal Court will not withdraw its arrest warrants. So we still have a window of opportunity to establish several more international accountability mechanisms to build this parallel independent justice track. I mean, Special Tribunal on Aggression, International Register of Damage, and reparation credit, because justice has a financial side, and we have 300 billion of Russian frozen assets, which has to be used also for compensation for victims from Russian war crimes. So regardless what's going on in this political process, which was initiated by President Trump, we have to do our work. We still have this chance to build future with justice, which we want for us and for our children.
And we should continue to do that with or without America.
I'm sorry, I didn't hear. To continue to do what the question was?
Continue to do that as best we can, the countries of Europe, without American support, if necessary.
The first step, it's obvious. We have to practically establish Special Tribunal on Aggression. And that is why I asked what we together can do to convince other countries to join. Because for current moment, only several countries joined to Special Tribunal on Aggression. And yes, the next steps are about creation of judges, hiring the prosecutors, creating the apparatus, and waiting and establishing the physical presence of this court, I hope in The Hague. But as I know, Netherlands are still in negotiation with Ukrainian authorities about this. I don't know how much time we have. And that is why I tell that we have window of opportunity. And I always asked, do I believe that it will happen? I can't predict future, but I do believe that we must do everything in present to make it happen.
Well, thank you very much for devoting time this morning to telling us your side as the bombs fall and the drones bomb and we read about your oppression. Thank you for being here. Now,
thank you very much for solidarity and support.
Let me come to Eurojust. You're still putting money in this tribunal. You believe in it.
Thank you very much. Indeed, I believe that the real question behind today's discussion on the Permanent Court for Aggression is not whether we face a gap in international criminal law. It is whether we need to deal with a gap in political will, authorization, and enforcement. But, and it's a big but, that does not mean the answer is yet to build another institution. I think so. The legal architecture to address these issues and hold the leaders accountable already exists. We have the International Criminal Court. We have the domestic prosecutions based on universal jurisdiction. We have tribunals. We have sanctions regimes. and we have the framework of UN Charter governing the use of force. I think the core issue is not whether we can design a new court. It is whether we can design enforcement architecture that is constitutionally coherent within the existing international law. At Eurojust, I would say we are quite well placed to discuss these issues, to address these issues, because we work at the operational end for international justice. We do not prosecute cases ourselves, but we support national prosecutors in their investigations every day. And through our work on the crime of aggression against Ukraine, including the hosting the International Center for the Prosecution of the Crime of Aggression against Ukraine, indeed we clearly see where investigations progress, where they stall, and why. Prosecutors, indeed, from joint investigation team, they are working very closely together. They sit side by side to collect evidence of aggression that can serve future trials. So from that experience, I would say the conclusion stands out that the problem is not the absence of law. The problem is how the existing system functions in practice. And I would say that we should strengthen what we already have. We should strengthen, we should make the system that already exists, especially the International Criminal Court, more effective, more efficient, coherent, and capable of delivering justice where it matters most. And I just could say accountability indeed is possible. Very recently, Ukraine has extradited a Russian soldier to Lithuania to be prosecuted for the war crimes committed in Ukraine. And for the sake of peace, I think for the sake of justice, we should continue down this road.
So you would continue with a criminal kind of prosecution rather than the civil court proceeding that Albi had suggested. And would you find the same enthusiasm and dedication to it, do you think, if it were a civil proceeding?
What do you mean by civil?
Well, as described by Albi, one that would not end up with any penal consequence, no one would go to jail.
Everything depends on you cannot force any state to sign, to be part of any other agreement. I think we have to do our best to push, to execute that political will to join forces and to unite.
Let me ask, as I can see him on the screen, that most successful of international prosecutors, Reed Brody, who was behind the prosecution of Hissène Habré, the torturer of Chad, who finally jailed in Senegal. So, Reed, good to have you. What is your view about the importance of a criminal prosecution, albeit one that probably won't get anywhere, against Vladimir Putin, the great aggressor of our time, or the kind of Magnitsky style of proceeding in which a court decrees them suitable for sanctions?
Thank you very much, Jeffrey. I should say, as Alexandra said, it's a little difficult to hear from out here. You know, for me, the central challenge in prosecuting the crime of aggression is actually double standards. Russia launched its full-scale invasion of Ukraine and committed mass atrocities in 2023. In January of this year, the United States launched a military strike on Venezuela and captured a sitting head of state. I think international law and institutions need to address both situations or any such situations. Otherwise, the prohibition on aggression is undermined. And I think this is a question of political will. I think we have to be cognizant of what is going on. And first of all, I think, as Alexandra said, as many states as possible need to join the Special Tribunal on Aggression. But we also have to amend the Rome Statute. As you all know, the reason why the ICC is not prosecuting Vladimir Putin for aggression is because it can only prosecute aggression by states which have ratified the ICC statute and have additionally consented to the ICC's aggression jurisdiction over its own citizen. That legal gap is the product of bullying by the UK, France, and especially by the United States, which is not even a party to the Rome Statute. Last year, 2025, there was a meeting of ICC states parties to look in particular at amending the statute to bring the aggression jurisdiction in line with the rest of the ICC jurisdictions. And that was kicked over. Basically, there was no consensus. Again, the same states mostly, plus Japan, opposed that. I think, if we're going to, I think the Special Tribunal for Aggression for Ukraine is a huge step forward. Even, I have to say, even, as Alexandra said, Nuremberg was double standards, but it's Nuremberg. It guides us. The Special Tribunal on Aggression for Russia is double standards, but it guides us. And I think we have to take what we can get, but we also have to be very aware that justice cannot be riddled by double standards. And finally, I think we also have to deal with the Security Council. When geopolitics paralyzes action, we need to find a way to move around the Security Council, particularly when we're dealing with mass atrocities. I think we have to proceed. I don't think we can have blinkers here to the big issue of double standards. Nuremberg called aggressive war the supreme international crime. If we believe that, we must be prepared to prosecute it everywhere by everyone, or we should admit that the law still stops at the water's edge of power.
Well, thank you for that thought that, of course, Nuremberg was a victor's tribunal in the sense that victory brought the opportunity to do justice to the perpetrators of the Holocaust. And that is perhaps what Nuremberg is best remembered for a judgment that put an end to Holocaust denial. Very difficult to maintain that the Holocaust never happened in the teeth of the judgment at Nuremberg, which set out the evidence that it did. And if that is perhaps the greatest force of international law, a judgment as to the truth of the matter, then isn't it better to have a court that can at least deliver that judgment based on evidence, rather than to tie our hands, as the ICC has tied its hands by refusing to contemplate trials in absentia?
I'm sorry, it is difficult to hear. Did you end up by talking about trials in absentia?
Yes. Can you address that question?
Yes, I mean, as a common law, Jeffrey, like you, as a common law trained lawyer, the idea of trials in absentia it never, it always offended me. And yet now, the more that I listen to particularly French-speaking jurists, the more I work in French-speaking and other jurisdictions, I see the importance that as a way of finding facts, as a way of honoring the truth, of honoring victims, that you can build, as long as you go, I mean, under the French system, the accused can have lawyers, there can be a relative amount of due process, similar to the confirmation confirmation of charges hearings now for that happened for James Friconi of the LRA. I have no problem with that at all. I think it's a step forward, and we build law, but I do think when the full-scale invasion of Russia of Ukraine happened, and there was this huge international response. Countries sending, the ICC creating its largest office ever, 14 states building universal jurisdiction, the Ukrainian justice system, everybody sending experts. And we all said, wow, this is the way all atrocities should be dealt with. And we applauded it. And then a year and a half later, we had Gaza. And it showed that this is not what happens and so I think we have to push for what we can get, but we always have, as like I'm doing right now, we always have to talk about why these double standards. Why is it only? I mean, since including Nuremberg. And until the arrest warrants against Netanyahu and Yoav Gallant, the instruments of international justice had been almost exclusively trained on defeated adversaries, as in Nuremberg and Tokyo, outcasts like Hissan Habre or other African leaders, or enemies of the West like Putin and Milosevic. And I think at some point we have to really take stock of that and make that part of our discourse.
Thank you very much for joining us this morning. Well, there is a view, an importantly changed view, of the possibilities of trials in absentia, which are necessary in any aggression court if it is to have defendants at all. Any thoughts on that?
On trial of absentia. Yes, also concerning Nuremberg, the main value of Nuremberg is not that the 17 persons were prosecuted. The main value is the examining of the system which leads to the Second World War. And this is, the persons convicted are gone already 80 years. But this evaluation is the basis for the modern international law after 45. And therefore, I don't think that it is a problem to have prosecutions in absentia, because many continental states have this already. I know that in common law it is unusual, but it is common law only for common law countries. And I think international law should follow the goal to to try to establish justice. By the way, we can see in the last years the international law is becoming more fragmented, and the relevance of international law and the global international law, and the relevance of UN as a global global organization of states is decreasing. But we should do also practically what is necessary, and I see the emergence of regional international law. It existed already before, but it became more relevant. And now concerning European regional international law, I think we are entitled and we have the task to guard these principles of non-aggression, of justice, and it is possible by a special court of aggression, because as we already heard, that the International Criminal Court is blocked in this respect, and there is no prospect that it could be changed, the statutes of ICC. And of course, a pragmatic approach is to do what it is possible. And since, I think in June 25, the agreement between Council of Europe and Ukraine was signed about the establishment of special court. It is a new court, but we have already Sierra Leone and Liberia, and just also for one person of the murder of Haddad, former Prime Minister of Lebanon, international court was established. Of course, it was with the will of United Nations, but now we have the problem that United Nations are, in this respect, dysfunctional, but it is also a pragmatic approach. We should not be hindered by this dysfunctionality for eternity. So the statutes of the Special Court of Aggression against Ukraine are already adopted. But now there is the process of establishing of the court. This may be provided for 1-2 years. There is specific advanced group already established, which is preparing the establishing of the court. And I think this should be established. Also, I see this, unfortunately, not as a development of a global international law, but good enough as a development of a strong European regional international law which forbids aggression. And by the way, the aggression and crimes against humanity, a crime of aggression or prohibition of aggression is the main instrument of peace. And the crime of aggression, that means that is, so to say, stressing this violation of the obligation to peace. And it is different and independent from the crimes against humanity. We have already seen that against Putin there is an arrest warrant for an international criminal court for this part of international crimes, but not for aggression. But aggression is a important, or for prohibition of aggression is an important part of the obligation to keep peace. And I think we should also promote that. Thank you.
Unfortunately, we can't, because Russia is not a member of the ICC, and additionally, it's not a member of the subgroup that acknowledge and accept charges of aggression. There are only 45 countries that have accepted that, and they are countries that would never act as aggressors.
Thank you. My name is Yossi Beilin. I was Minister of Justice of Israel 100 years ago, about 100 years ago, and I'm not a lawyer. I'm worried about trial in absentia. I think that it should be an option, but one should be very careful in using this option, because it may quite easily become a tool which will be supported in too many cases. And the court will be, the international court will be bombarded by ideas of abstention trials. So in that case, I say don't give up on the option, but don't use it unless it is very, very unique. And if I may add something, the fact that the United States was never a member of the ICC, which is also the case of China and Russia, is very problematic. It reminds me the League of Nations. I mean, President Wilson came to the world and said, I would like to suggest you an idea, and his country was not with him, and he could not convince his Congress to join the League of Nations. Russia was there at the moment and then left. And to have an international organization without such important countries made it, I mean, many others left the organization, and the end was very tragic. So I think that we should think about catering to at least some of the needs of these superpowers in order to convince them to join, rather than to bypass them through the council, to the Security Council of the UN. You know, I remember in 2000, I tried to convince my government to join the ICC. I really believe that it is a kind of a miracle, at least for my generation, that something like that exists. And as you said, it was actually established because of something which was very close to us, and that is the Holocaust. And the government decided to follow the Americans, surprise, surprise. And it was a very tense moment, because the Americans or anybody had to join the court until the 31st of, I think, December 2000. And then at the last moment, Clinton joined. And I called the prime minister and I said, he joined, we can join now. And we joined. We joined the covenant, but we never ratified, because the Americans did not ratify it, regretfully. It means that at a certain moment in history, it is not impossible to convince the United States, and maybe also other countries, to join with it. I would like to strengthen it rather than to give up on it. It is too early.
Too early to abandon hope of the ICC?
The precise questions. How can we hold heads of state accountable for wars of aggression? Involve a subject, the head of state, and a predicate, waging war. So, can we hold the aggressor head of state accountable? In my opinion, there are only two ways: either by a military coalition winning the war, as was the case with Chancellor Hitler at the end of World War II, or by removing the aggressor head of state from power internally through a grassroots democratic movement, as was the case with Serbian President Slobodan Milosevic after the end of the Cold War. I am very familiar with the second case, because I was president of Romania in this period, in all these phases, not only because Romania is Serbian neighbors, but also because I personally knew all the political and military actors involved in the process and participated in many actions related to resolving the complicated problems of the transition from communist dictatorships to democracy in Eastern Europe after the collapse of the Soviet Empire between 1989 and 1991. It is not possible to present this event in 2 minutes or 20. So for those interested after the Berlin World Forum, I can forward a more detailed account of this process, which President Bill Clinton, evoked by you, worked assiduously to resolve throughout his term in office, and to which we, the democratic president of the Eastern European countries, also contributed significantly. For over 3.5 decades, I have taken part in many international conferences in the academic, political, civic spheres, many of which featured many beautiful speeches that know nothing. I see our meeting today as a conversation between individuals who can share their own experience in resolving difficult situations. In the case of Milosevic, was the difficulties and unresolved issues that made the case difficult to use as an example. In conclusion, President Milosevic was considered in turn, not only in Eastern Europe, but also in Western media, an authoritarian leader or a reformer, a pillar of peace after the Dayton Agreement, and a war criminal. He was arrested, extradited, and imprisoned in The Hague. He died in prison, but his trial continued after his death, and ultimately the Hague Tribunal acquitted him. It's very, very difficult to resolve this problem.
Thank you. Let me turn to this side and ask you what you think of the idea that Albie floated, that we can have an international court, but with only civil sanctions, such as recommending Magnitsky-style actions. Mark Stevens.
It's really easy to get exasperated with the traditional notions and arguments. Let's remember that all international crimes start with one decision, a decision by people in power to use force. If we only punish the crimes that follow, but never the decision that caused them, then we're treating the symptoms and not the disease. And what I liked about Albie's suggestion was that we use Magnitsky sanctions as a way to move forward. But I don't think you can limit them in that way, that it's just a civil use. Why can't a criminal tribunal impose Magnitsky-type sanctions, take away the fruits, give them an incentive to come and vindicate themselves before the court if they wish to? And if it's a trial in absentia, why don't we impose Magnitsky-type sanctions? Because that will have bite, that will have impact. You may not have the body, but you will certainly hit them in their pocket, and that's what's going to matter to them.
Tatiana Ritwell.
Thank you so much. I find what Mark said there quite interesting, actually. I just wanted to say there's a few themes that come out around this round table. And one of them is certainly the idea of the risk of selective prosecution. And I think one of the risks of the tribunal of this, of prosecuting crimes of aggression, which are crimes against state sovereignty, as Professor Teitel pointed out, is the notion of a just war, that from every decision flows war crimes, crimes against humanity, the injustice of war. But that the notion of just warfare is imbued in this prosecuting of the aggressor. And it's very important not to forget that even, and I'm not specifically talking about Russia-Ukraine here, but even a state that is fighting a war, a conflict in its self-defense, can commit war crimes, crimes against humanity, etc. And that this part of the conversation needs to remain, and states that are prosecuting wars but also defending wars need to be scrutinized in a tribunal. And secondly, I think it's very important not to conflate aggression against state territory, with those underlying war crimes, crimes against humanity. Drawing on Mark's point and talking about a criminal tribunal imposing, this is a criminal tribunal. And around the room, or in sort of the discourse about the Russia-Ukraine and this crime of aggression, is the notion that Vladimir Putin will be found guilty. Should he eventually stand trial? Should he ever relieve himself of his position as head of state? Because, of course, the statute of the tribunal recognizes personal immunity, and any indictment against Vladimir Putin will be suspended until he is no longer the head of state. So should there ever be some prosecution, it is assumed that the evidence will be, I was a criminal defense lawyer, the evidence will be available in order to prove beyond reasonable doubt that Vladimir Putin made the order, that he made the preparation. And there's a real danger, I think, with identifying a tribunal for one cause, as Albie Sachs pointed out, in assuming that we will get the result that we're all looking for. And so there's a lot of hope pinned on this tribunal. And I think what in its discourse, in setting up, it's incredibly important symbolically, but there are other means of creating historical record and providing accountability to victims, perhaps through a different mechanism and more robust mechanism in the UN.
They are not means that have the imprimatur of an international court finding on evidence. I suppose as a defense lawyer, you would take every point that you could. And this is the problem with, for example, a tribunal in Holland that looked at the shooting down of the Malaysian airline. They gave the Russian defendants, they tried them in absentia, but gave them no lawyers. So it would be essential, if there is a trial in absentia, to have good defense lawyers. I'm thinking of Alan Dershowitz rather than Rudy Giuliani, but to defend Putin. But that would be essential before the world can concede that such a tribunal would be fair. But is there any reason why it couldn't be fair, given that either side could call experts, could call witnesses, and are free, subject to the absence of the defendant by his own choice, to compete and to deal with any charge that is made?
Within the statute of the tribunal, there has that principle that any trial in absentia must comply with the right to fair trial, the person must be represented, and indeed they have the right to come and have a trial should they wish in the future. But I think it's, what is the purpose of this trial that we're looking for? Looking for to punish, looking to prevent and deter, and having a special tribunal for the crime of aggression in Ukraine will not deter Vladimir Putin from prosecuting future wars. So I think whilst it's important to identify individual responsibility for these offences, I'm not discounting that at all. I think in tandem one cannot rest the whole idea of prevention and deterrence within the individual criminal responsibility structure. And we see that with the ICC. We see that with domestic criminal law. We have laws for murder. People commit murders. So I think having an alternative system whereby, or using the tools we already have available within the international system in order to identify how to make prosecuting wars, aggressive wars, costly to the person, so that they cannot hide behind the veil of the state, would be more effective deterrence.
Well, of course, Magnitsky could come with social isolation, refusal to contract Russian opera singers and Russian tennis players. Look at them playing at Wimbledon. Their country is not mentioned on the scoreboard. Is that sufficient, or do we need more severe measures, such as declaring their diplomats persona non grata and because their diplomats, after all, are perhaps the most guilty, since they know of the illegality and continue to mouth Mr. Lavrov's lies. You wanted to add?
Well, thank you very much. I wanted to emphasize that indeed we need in international tribunals to maintain the protections we know from human rights law and domestic law. We had lots of problems with the arrest warrant in the European Union with ordinary crimes with regard to the trial in absentia, but there is a solution. The solution was that Italy and France changed their law to allow for trial in absentia, but to provide a new trial when the fugitive is present. And I think that is very essential also for international acceptance. So we shouldn't let us divide between human rights lawyers and international criminal lawyers. I think that's an important point. And what we really have work to do is on two things, I think, mainly. That is the extension of the jurisdiction of the International Criminal Court. Aggression should be a crime like the others. And for the other crimes, it's enough that the victim state has consented to jurisdiction, either by permanently becoming a member or by consent ad hoc. So for aggression, the same should be valid, but it has been blocked. And for the Special Tribunal, we have to work on immunity. And immunity is a question of acceptance, and the ICC has even problems with its ordinary crimes with regard to Vladimir Putin being received in Mongolia. Mongolia is in a difficult situation between China and Russia, of course, but we have also Hungary leaving the court and also allowing Netanyahu to visit. So the real point there is on immunity and on not recognizing a state immunity. And it will be interesting to see the Venezuelan case, because Maduro is now in New York before a US court. And the one immunity which the US has always required, asked for, was the immunity for heads of state. So we will see what they are going to do with that.
I think we all know Mr. Maduro is going down for a long time. But be that as it may, Albie, we started with you and put you on the spot. Has the discussion brought any more thoughts?
Yes, one through a little memory. Last year, the G20 was headed by South Africa, Cyril Ramaphosa, and 19 of the 20 turned up in South Africa, and the 20th one didn't, and that was Vladimir Putin. And he didn't turn up because some years back, the war criminal facing charges from Sudan, Omar, was in Johannesburg. A civil society organization went to court and said there's a warrant for his arrest out, issued by the ICC, and he must be arrested. And that warrant was issued. He had just enough time to get out of the country. So Vladimir Putin knew if he came, a similar warrant of arrest would be issued, and it was actually meaningful. It was more than a slap on the wrist. It was like saying, you're different. You've been condemned by a court in that particular way, and you're not safe. So maybe that subliminally helped me think of the idea. And if one wanted to be more robust, one could say, we will also, the grouping of the willing, tell you that if you come to our country, we will charge you. A kind of universal jurisdiction, criminal punishment will face you if you come, and meanwhile out there, don't have any dealings with us. The last thing I'd like to say is I was so moved by the presenter from Ukraine. You know, it reminded me of the apartheid days. There's an anguish when you are being bombed. These are not just issues for lawyers to throw around and test. They are those issues, but you feel it with an agony. And even the calmness of the lawyers talking becomes irritating because it's in a different realm. You know, they're not facing what we're facing. And yet, what I can say to her was we did win through in the end. The agony did come to an end, we did have to create a multiple variety of responses for accountability. Sending someone to jail is not the only response. We had a truth commission that was enormously important. Thousands of people took part. It dealt with human consciousness, it dealt with pain, it dealt with storytelling. And I think sometimes we become over-fixated with prison, now that we've abolished capital punishment with hanging, as the accountability. And it's forbidding us to explore more effective, more participatory, more far-reaching, more intense forms of response.
Thank you very much. On that note, we'll leave the permanent court for the crime of aggression, at least for another year. We might check out its progress at the next World Forum. Thank you all very much for attendance. I gather there's an opening in a few minutes in the main hall.